Ready? Start. For any criminal proceedings to initiate, the starting point is filing of a complaint and registration of FIR. Stop. The complaint provides the first account of the happening of events and incidents alleged as commission of offence. Stop. A reaction and revelation at the first blush is always natural and therefore becomes creditworthy. Stop. The contents of the complaint giving the initial and primary description could be treated as more reliable, at the subsequent stage, there would be a scope and room for improvisations. Stop. Para. In state of Haryana and others versus Bhajan Lal and others, this court laid down the acid test that if the contents of the FIR, taken at their face value, do not make out any case against the accused, such an FIR registered with ulterior motive deserves to be quashed. Stop. In Hitesh Verma, supra, in addition to the ingredient of code a place within public view, uncode, the details in the FIR or the charge sheet failed to disclose the precise contents of abusive language employed by the applicant to attract the offence under the SC/ST Act. Stop. In other words, when the essentials to constitute the offence did not come out from the were not satisfied in the contents of the FIR, the offence was held to have not been made out, rendering the FIR liable to be quashed. Stop. In Amarnath Jha versus Nand Kishore Singh and others, this court noted that the defect in the FIR was in the nature of non-mentioning of the name of material witness PW1, which was treated as a basic defect in the hypothesis portrayed by the prosecution. Stop. The court, in that context, observed, although we accept that the FIR need not be an encyclopedia of the crime, but absence of certain essential facts which are conspicuously missing in the present FIR, point towards suspicion that the crime itself may have been staged. Stop. Also in Ramesh Chandra versus State of Uttar Pradesh and another, this court found absence of requisite ingredients of the offence under the SC/ST Act, holding that the offence was not committed at code a place within public view, uncode, full stop. It was observed that even though the appellant in that case might have abused the complainant, but such abuse by itself and without anything more does not warrant subjecting the appellant to face a trial, particularly in view of the clear absence of the ingredients necessary to constitute the offence. Stop. Thus, it is right principle that the FIR becomes liable in law to be quashed when it, in its bare reading, does not disclose the necessary ingredients to constitute the offence alleged therein. Stop. The basic constituents of the offence alleged in the FIR must stem and stand disclosed from the contents of the FIR. Stop. In order that the FIR alleging any action is sustainable in law to be a good and acceptable document to proceed criminally against any accused named therein or any person to be made accused on its basis, it must manifest and reveal basic ingredients of the offense alleged therein. Stop.